Welcome to a live episode of Surviving the Survivor. We bring you the best guests in all of true crime. Don't forget to subscribe and smash that like button. Here's your host, Emmy Award-winning broadcaster, Joel Waldman.
Hi, everyone, and welcome to Surviving the Survivor. I am not Joel Waldman. He's actually on the road on his way to Tallahassee, so I am filling in today. Hello, welcome. I'm Ileana. I'm also known as the STS COE, or Joel's wife. And welcome to two of our amazing guests. You guys all know Tim Jansen. He is the best guest. He's a phenomenal attorney there in Tallahassee and has an in on this specific case since he is a local there. We also have another best guest who is also an STS member, and that is law professor Joe Patuto. And welcome back to both of you guys. Thank you for being here today.
Thank you, Ileana. I've got Kathy Kool-Lady here in my office. You want to say hello to Joe?
Yeah, tell her to come say hi.
He is coming forward.
She's got a new haircut. Your haircut is
Hi,
terrific.
how are you?
I'm in the audience now. It's a live audience here.
We were having lunch
I love
today.
Very good. All right. Well, Tim, why don't you get us up to speed and tell us why we are suddenly going live right now?
Okay, so it looks like at 11:18 today, the state witness, they basically filed a motion saying that Michael Offerman, the appellate lawyer, saying that Charlie is not waiving his privilege with Dan Rashbaum, meaning he represented him previously, and if the state calls him as a witness, he's not waiving it. So Dan has a conflict in cross-examining him, because you can't cross-examine a witness with someone that you had a privilege with, because you had information you're supposed to go to your grave with unless the client waives. He's not waiving. He also argues that nobody on the defense team, there's no Chinese wall built up, so Alex can't do it. Now, in response to that, Donna's lawyers, through Alex Morris, says, one, there was a Chinese wall built up. He knows nothing about the prior communication and privilege. And if that doesn't work, we are willing to bring in a third-party outside lawyer to do the cross-examination. We don't have a response from the state yet. We're waiting for that.
And talk to me about the timing, and this can be for either Tim or for Joe. Obviously, jury selection starts tomorrow. Was this strategic in the timing, or why would this come up now as we're, less than 24 hours away from jury selection?
Joe, do you want to take that?
Well, all I'm going to say is I don't have a good guess about it. It doesn't seem to me that there's anything particularly strategic. I mean, if there's going to be a cross-examination, there'll be a cross-examination. I think the timing is remarkable. And it seems to me it's not inadvertent, but what exactly they're trying to get at it, I don't know. I find it peculiar, and Tim, you may know this better than I, why they felt they had to do this through two motions rather than just addressing it with Judge Everett in terms of what's going on. And the other thing I don't understand is I thought these conflicts were waived last week or the week before by both sides.
Okay, so that's a good point. That was a different conflict. That was a different conflict with the advice that she gave, or he gave Donna about going on the airport, that Daniel, you're not going to be a witness in this case. Now, if you want independent counsel, you're not going to be able to argue that Dan's going to be a witness. Okay, I think this was strategic because, one, the state had their witness list out long ago, right? And they had Charlie Adelson on it. So they had to know that there was a possibility that unless Charlie waived it, there was going to be a conflict. And Daniel would have had to contact the bar and see what his ethical obligations are. But they probably prepared that because they say in their response that they built up a Chinese wall for Alex. So they knew this could be a problem. So the motion there's two motions, because one is by his appellate lawyer, Michael Offerman, who's trying to protect his client, and the appeal citing all the bar requirements. So the judge is
Right.
going to have a hearing and have to determine if Alex is a sufficient wall. And then there's going to have to be a hearing whether, if that's not enough, will they have to bring an outside third-party lawyer in? And is that lawyer going to be ready to cross-examine? And how will he prepare without being tainted from the other lawyers?
Exactly.
Well, and
So-
Joe, what about the fact that this is happening now, jury selections tomorrow? How quick of a turnaround are we going to see? I mean, do they now have to address this before jury selection, or like, will this push back the timeline?
Well, I would guess they're going to have to do it. What surprises me is I thought all along that Charlie being on the state's list did not mean he was going to be testifying for the state, because I couldn't figure out what he would testify to that would help them unless there was some sort of deal. This suggests that maybe the state does plan to call him. But it seems to me they've got to do this before they impanel a jury and sit a jury. Who knows how long this will take? And if Judge Everett decides that the co-counsel, even though there's a firewall, can't do it, then Tim is right. The time at which a new lawyer would have to come up to speed to be able to do an effective cross-examination. I don't know how much time it would take, but I don't think you want to have a jury sitting while that jury is coming, that lawyer's coming up to speed. It's peculiar.
The bigger problem is going to be who is going to get that lawyer up to speed without going through Alex or Rashbaum. What's he going to do? Sit down with the state attorney and look at the documents in a cleansed atmosphere? That doesn't work.
And that's going to affect Donna's Sixth Amendment rights if this goes to trial, if we go forward and there's a conviction, because that's going to be the first appealable issue she'll be able to raise, that there was not an effective cross-examination of one of the major witnesses against her, assuming Charlie testifies for the state.
And pardon me, both of you, I obviously do not have a legal background. So what happens next? This motion was filed. Obviously, it's a big deal. Now what? Can they have a closed door, hearing to discuss this motion before tomorrow? Do they have to push it back? Does this have to be addressed before jury selection can begin, or can they handle both situations separately and address it before? I know in different cases, like the Michelle Troconis trial, they kept addressing various things as the trial was going on. But does this have to be addressed pretty much over the next 24 hours?
Well, the judge is not going to want to pick a jury and do that until this is resolved. Because
the judge is not going to be happy, right, Tim? This is not going to be a happy camper as a judge.
The problem is the judge would hold Daniel Rashbaum very serious, to the feet to the fire, because they should have filed this motion months ago, weeks ago. They didn't. They just sit there laying in wait, file this the day before jury selection, knowing that they've got a potential conflict, knowing they don't have a waiver, and then throw out there that, oh, well, we got this Chinese wall and we'll bring somebody else in, third party. Judges don't like this. They would overturn a conviction if they don't adequately cross-examine them, or whoever they bring in is not adequate. It is an issue,
Right.
and it's a terrible issue to be brought up at this point.
And I'm reading this motion again quickly. I don't see that they've said that they know who this, assuming they're bringing in another lawyer, who this other lawyer is. And if they have another lawyer who's ready to go, then they would have prepared some of this in advance before this motion was filed.
That's right, which means they probably have contacted somebody to possibly come in, and then that person's going to have to go under oath before Judge Everett to determine what he knows, what he was told, who told him, when did he get it, and when. And how can this person say, I'm ready to go, if I haven't reviewed materials or talked to the present lawyers?
Exactly.
This is nothing but time bomb for Judge Everett and this trial.
And this is by a defendant who said she wanted a speedy trial. She didn't want to be delaying. And now all of a sudden, there's, I think you're right, Tim, a time bomb in a trial that they insisted they wanted to go right away.
So judge will have the jury come in. They'll do the preliminary screening. And what he'll probably do is, okay, we're going to go until 1 o'clock every day on Tuesday and Wednesday. And then we're going to have this, we're going to flush this out from 2 to 5 or how long it takes before the jury is actually sworn in and picked. That's one way he can do it.
All right, I'm trying to pull this up here. Apologies if I look distracted because I am. A little hard to multitask. And as you guys know, I don't do this often on camera. So I'm pulling this up here. I'm going to try to zoom it in. Let me know if you can read it or if it's still too difficult. Can you read it, Tim or Joe?
I have mine in front of me.
Yeah, and I can read it. Yes.
Okay.
That's
Okay.
good.
So I just want to share this with everyone. That way they can read it as well. Hold on. Let me pull this up here. Okay. Tim, do you want to just read that for us?
All right. So the trial is presently scheduled, right? Blah, blah, blah. Charles, through his counsel, has filed a motion to preclude former counsel, means stop, Daniel Rashbaum from cross-examining him if he's called as a witness in the proceedings where Mr. Rashbaum represents his mother, Donna. And then number 3, you can scroll down or scroll up. As this court is aware, the undersigned, number 3, was brought into the case January 24th. So that's when Alex was brought into the case, January 2024. So he's drafting this motion. While defense counsel believes that an ethical wall, and what that means, an ethical wall means he did not have any contact or any communication or reviewed any materials that was privileged between Dan and Charlie. So there's a wall, right? So he wasn't tainted, as they call tainted, from information that Rashbaum had. And if that doesn't work, they said we have a third-party counsel has been secured specifically for the purpose of examining Mr. Adelson if the needs arise. My question is, wait a minute. You knew this was a motion. You knew this was a conflict, but you already got somebody and you've already paid them. You've already hired them and they're ready to go. This motion should have been, I want to know when you hired this lawyer, when you paid for the lawyer, why didn't you file this motion with the court to keep this record clean?
And Tim and Joe, people are asking, is this intentional sabotage? If this was premeditated, why wasn't it addressed before? Would there be any logical reason that this wasn't tackled before and now would have to be addressed? Would there be anything that could be a last minute change or anything?
The judge can hold him in contempt, or he can tell him you waived it. But what does that do to the trial? It taints his trial. It taints a murder trial. You don't want to go through a murder trial knowing this is going to be overturned on purpose. And it was purpose. They're going to benefit, which means she's going to get another trial if she's convicted.
Right.
I
can't imagine that the judge would do that, as much as he might want to refuse to allow this to go forward and risk what seems to me would be an almost inevitable success on appeal, because her Sixth Amendment rights are being affected by all this. However many times she may have said this was all right.
And she can say, I wasn't confused. I really didn't understand. And trust me, you'll get a lawyer on a 3.850 motion, ineffective counsel. He didn't really tell me all that. I didn't know all this. I'm not a lawyer. I want a new trial. And
the other day, Joel asked us both what we would tell in terms of good advice for lawyers. And I thought about it afterwards. And I would have said, or would say now, that your reputation is what you have beyond everything else. And if you lose your credibility with other lawyers and with judges, that is something that you just cannot recover. And this one feels this way to me, that this sort of what appears to be, unless we find that there's some responsible explanation that I can't come up with, it feels to me like a shenanigan, that this shenanigan inevitably affects the reputation of at least one and maybe both of the defense lawyers with the practicing bar and with judges they may come forward. This is not where a lawyer wants to be.
Well, and question. So you said that they mentioned that they hired someone or had someone available for this. Do they have to disclose who that is, when they were hired, what their involvement has been? Like, do we know anything about this, or we just know that there is another attorney who's just waiting on standby?
So what they say in paragraph 4, if you go back up to 4.
Oh, yeah. Hold on. I
While
lost my tab.
Okay. Defense counsel believes an ethical wall has been created. The third party counsel has secured specifically for the purpose of examining Mr. Adelson. And then the last sentence, communication with the third party has been restricted to confirming his availability and a conflict check. Conflict check means to making sure this lawyer didn't have any other involvement, relationship with any other witness in the case, anybody for the state. So they've gone to the point where they have a lawyer in waiting, and all they said they've done was ask him if they're available to be hired or hired only for the purpose of cross-examining Charlie. Now that lawyer, I don't know who it is or who she is. Anybody that would agree that I'm going to cross-examine the co-conspirator a day before the trial and say they're going to be ready is ineffective.
Yeah, I agree.
And Jamie Palizzi here is asking a question. This is crazy. Can Everett shut this down without risking Donna getting a new trial?
Well, nothing's happened so far. Jury has not been impaneled. The first witness has not been sworn. There's no jeopardy. So with regard to the trial and Donna, postponing this has no impact on any of her rights, particularly since it's coming from the defense side, the solution and the holding back the information. But what it does do is it appears it has the prospect of delaying the start of this trial, unless the state comes forward and says it has no intention of calling Charlie, which may be part of the reason for all of this, to get from the state information as to whether Charlie's going to be called or not, and a commitment from the state. Because if the state says it has no intention of calling Charlie, and there's this looming conflict sitting there, the state won't be able to change its mind later.
So that's a great point. We're watching the docket right now to see what the state refiles. So they could have the state could say, we're not going to call Charlie. Remember, the state has a right to a fair trial also. So what the judge will do then he could bring Donna in and say, Donna, it looks like we're going to have to continue your trial. I'm going to have a hearing unless we have this hearing. We either accept that the wall's been up, and or the new lawyer comes in and tells me he's satisfied, and you waive any appellate issue of this lawyer handling the cross-examination, and you waive anything else, we're going to have to continue your trial. Put the onus back on the defense, and he's going to want to know when they got this lawyer, when did they realize it was an issue, has your lawyer discussed this issue with you?
Yeah, and it seems to me that the very latest they can say they had wind of this issue is the first time the state had Charlie on its witness list. Because
That's right.
At that point, it couldn't be any later than that when they were on notice.
Joe and Tim, we have some people that are just joining us. In fact, we also have the host of Surviving the Survivor, Joel Waldman, joining us. He's listening in on his drive up to Tallahassee with STS producer extraordinaire, Meave Moen, aka Steve Cohen. So for Steve, for Joel, and for those who are just joining us, can you give us a quick recap? Give us like a 2-minute version of what's going on and why this matters.
All right. So Charlie has been listed as a witness for the state. And I don't have the exact date their witness list had him on it, but I assume it's probably been more than 60 days that Charlie's been listed as a witness. The defense, through Charlie, files a motion, or the appellate lawyer filed a motion saying that Charlie's not waiving his privilege. So now the defense cannot cross-examine Charlie. Well, you can't have a trial where the defense is not able to cross-examine a state witness. So the defense responds by saying, oh, well, we've got a Chinese wall and Alex, the other lawyer, doesn't know anything about the privilege. Or we have another lawyer in standby, right? Well, how long has that lawyer been in standby? And when did you do this? So you knew this was going to be a problem, and you waited till the day before jury selection. This is just bad lawyering, bad timing, but the court has very limited avenues to resolve it before the trial.
It seems to me, now that I've had 3 minutes to think about this, that the clean solution to this would be for Judge Everett to examine Alex and confirm that there is an effective Chinese wall there. Get Donna's assent to any potential issue with him doing the cross satisfied. And then the issue is the appellate lawyer, and I assume the appellate lawyer should be at this hearing also, asked whether and why that would not satisfy his concern with regard to his representation of Charlie. And
Joe,
then there wouldn't be any delay.
Yeah.
Sorry to cut in,
Excuse
but
me.
what would an effective Chinese wall be? And a Chinese wall, can you explain what that terminology is for those of us who are not in the legal world? But what would it take to make that effective?
Before we go forward, you should look at the attachment. There was an attachment filed that Charlie Adelson was served a trial subpoena care of Daniel Rashbaum. So not only did they know that Charlie was going to be a witness, Charlie accepted service on his behalf. So, and that says July 11th. Okay. That's July 11th. He knew he's a witness. And we're now September 16th. That's over 60 days.
So does that speak to the this Chinese wall of ethics, or is that a completely different issue?
Yeah, that's a different
issue.
Okay.
Chinese wall is like, say somebody in my office, we have 3 lawyers in my office, and one lawyer represented somebody in a case. And now that defendant is now going to be a witness against my client, right? And I never knew anything about that client. And my partner says, hey, Tim he hasn't seen the file. He doesn't know any privileged material. And we can effectively show the court, I don't have any information. And you do it in camera. In camera means only with the judge. There'll be a court reporter, it'll be under seal, and the court can have a record, and then he'll make an order and then inform the parties, okay, I've done an in-camera review. I'm satisfied that there is a Chinese wall.
Okay, got it. Hold on. Someone's asking here, how was Donna allowed to retain Rashi anyway? How was that allowed? Also, can either of you guys hear me? I'm being told that my audio is having issues, or we're good?
I can hear you great.
Okay, great.
I can too.
Okay.
Well, everybody has the right, the Sixth Amendment, the right to hire whoever they want. If you're charged somebody, you can hire whoever you want, okay? With limitations, though. There are some limitations. And this is one of them. You can't hire someone who has represented a main witness against you and have privilege. You cannot hire that person. So you can't always hire the lawyer you want, because that lawyer may have a conflict. And that happens all the time.
And this is for both of you. This is from friend of the show, Ada Shaw JD. She's asking Tim, but I'd like both of you guys to give your opinion on this. What do you anticipate the state will respond with? Excuse me.
Joe, what do you think?
I don't know. The state has to worry about 2 different things. One is preserving the evidence for the best possible presentation to get a conviction beyond a reasonable doubt. But secondly, the state has to have a concern about introducing an appealable issue that's going to have some legs on it at an appellate court. I don't know what it is, because I never thought the state would call Charlie. So I'm still astonished that they're intending to do it. I don't know what it is they are expecting to get out of Charlie that they think is critical to their case. And that has to weigh into the calculus about what the state's response is going to be to this motion. If they don't think Charlie's testimony is very important, they can say they're not going to call him. If they think the risk is worth taking because what he's going to testify to is substantial, they may decide to oppose. Without knowing what what they think he's going to say that's going to help them. I can't answer that question.
Yeah, I think the state wants to call Charlie. They can give him immunity, just like they give Wendy immunity, because they feel he's necessary to set up some elements of the offense that maybe they don't have a witness for, but they're going to use his testimony at his trial to fill in those gaps that is going to tie to Donna. I don't think they want to dump Charlie. I think, and this is my opinion, this motion was filed at the last minute so that the state doesn't want to move this trial. They'll just dump Charlie. And
Yeah.
I don't think that's a good thing for the state. If that's, I don't know their theories, but they may want Charlie.
Question for you both, though. So Crispy is asking this. She's asking, do they really need Charlie's lying testimony? Couldn't the state take him off the witness list to avoid this conflict delay? Obviously, it sounds like they're trying to strategize to do that. But even still, there is so much evidence that we, have seen and that we will continue to see in this case. Do they need Charlie? Do you think they need him to really solidify their case?
So listen, another piece of evidence came out at the last hearing. It was an email or a text chain. I think it was an email between Charlie and between Donna, right? And it talked about the reason maybe Dan got killed was because he was drug dealers and he didn't pay his bill, right?
Right.
That is crucial because that conversation undermines this whole extortion theory. If they were being extorted, why would they be talking amongst themselves that the reason Dan was killed was because of a bad drug deal? And that wants to come in. And who can they get that in from? They can get that in through Charlie, right? Charlie, you sent this email. You sent it at this time. This was after the double extortion, right? It undercuts the entire double extortion defense. And I would think the state wants that.
Well, and I would say, just to add to that, I would defer to the state's judgment about what evidence it needs in order to get a conviction. They're the ones who have the closest understanding of how they're going to put this case together and what's important. They think he's important enough. And I agree with you, Tim, and I was going to mention that. Do you know when they found that email or that text exchange between Charlie and Donna? Does anybody have the dates when, or would we know? We may not know. Because I'm wondering the extent to which that date corresponds with some of what I'm calling the shenanigan here.
That's a great question because it kind of, when we were watching the hearing last week, it just kind of popped up out of nowhere. And it was the first time I saw that email, and it was I'm like, my God, that's completely different than their defense. That cuts against their whole defense. Why would they do that? And
that would have gone to them in discovery.
Right.
At some point. And I think, I don't know.
Bichon Mama saying it's from 2016.
Okay.
I'm not sure about that, but.
Yeah, but the question is when they really noticed it, because it wasn't important to them until they learned about the double extortion theory, and they may not have keyed on it during that trial, because remember that theory came up at the trial, and they didn't go through all the emails and texts that they had. The question is when they went through it and found it, when then it showed up in discovery for the defense.
Joe, you're right, because Dan had this whole double extortion. No one knew about it until his opening statement, right? And so when they were preparing for the trial, that wasn't that relevant, right? But now it became relevant because it was after the arrest of Lewis and Sigfredo that they're having this conversation, right? Maybe he was killed because he didn't pay the drug dealers. So it clearly undermines their whole extortion theory. And maybe that's why they don't want Charlie to testify.
And what about Alex? Ada Shaw is asking another question. She's asking, do you think Alex knew of this move? He has a stellar reputation. What do you think his reaction could be?
I know Alex, and lawyers, as the professor says, it takes years to build your reputation. You can lose it in an hour. You can lose it in one case. But I believe probably what happened, Alex did build the Chinese wall. He may not have known everything that was going on, may not have been involved in the strategy sessions. He's been given a limited role of what he's going to do. He built the Chinese wall. It looks like he's been doing all the motions. If you see the motions that have been filed, he's been drafting in and arguing most of them. That might have been his role. So he may have limited information as to this unless we see something where he was responsible for building the Chinese wall from the beginning. He was responsible to get a third party in case that's a problem. But no one brought it to the attention of the court, right? No one brought this kind of conflict to the attention of the court, which is what courts require you to do. If there's issues I need to rule on, bring them to me. So that's not going to be good.
And if you're the prosecutor, what are you thinking right now? What are you doing?
I'll tell you what I would be. I would be really, really angry. That would be my first reaction. Anger. And it would take me a little while to come down from being angry to start thinking reasonably about what comes next. And then I think I would want some level of discussion within the office with both the state's prosecutors who've been handling the trial, but probably with others, just to think it through, because this is pretty serious and this is coming, snap, 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 and you don't want to make a decision without full reflection of all the consequences.
It just smacks me that you've got everything is all these witnesses, all these defendants, everybody, this little circle in South Florida, these lawyers, all this circle in South Florida controlling this case, controlling who can be a witness. Now it just seems like it's just not handled properly, and it wasn't handled in the open. And when a judge asked her about the conflict 2 weeks ago, why didn't Dan say, Judge, well, this other issue, we're building up a Chinese wall. We got another. They sat on their hands and never brought it up. And now judge has to see this the day before jury selection. He's not going to be happy.
No.
But he's got limited resources of what he can do at this point. He could continue the trial, and he can force the removal of Dan Rashbaum and Alex from the case.
And then we'll have a very long delay before this goes forward.
That's right.
And Tennis Girl 101 is asking, so Charlie's waiver way back when doesn't apply to the situation?
Charlie's waiver, what waiver did Charlie give?
Tennis Girl, we're going to have you give us a response to that. But in the meantime, I do just want to pull this up because you were talking about the delay, Joe, and La Mesa here putting up a comment, poor Ruth and Phil. And it really has been a long time for them. It's been 10 years. Everyone's getting ready. And now this.
I agree, but think of what it's doing to the witnesses and the progression of witnesses that the state is responsible for. You're giving them dates when they're going to be coming to Tallahassee. Some of them may already be in Tallahassee. They're disrupting their lives and their schedules. It's, with everybody being disrupted, I just think it is a terrible, terrible, terrible thing to do at the last minute in a trial with this many moving parts, this significant, where they had to have known for a while. What it reminds me of really is Daniel Rashbaum opening with the double extortion as here's my secret. And this feels the same way. I'm holding it in my hands and springing in at the last minute. I said lawyers have their reputations to run on, and when you lose that, you lose a lot. And I can't imagine that unless there's an explanation that I cannot think of, that this won't have a dramatic negative impact on the reputation of at least one of the defense lawyers.
So the waiver, CO, was the waiver on Donna gave the waiver. They never brought Charlie into the courtroom and got a waiver from Charlie. They got the waiver from Donna, right? Okay. And there's two waivers, Charlie's got his waiver that anything I told my lawyer while he was representing me is privilege. I'm not waiving that. And you can't cross-examine me because you have information that you're not supposed to have that you could use to trip me up because you got it from me as your lawyer.
Well, this is interesting because I had assumed, and I shouldn't have, I should know better, that they had to have some waiver from both sides, including Charlie, before Judge Everett would have permitted this to go forward at all.
Unless it's in writing, I never saw Charlie come into the courtroom
No,
under
I didn't.
oath and say, I'm waiving any privilege. He's not going to do that. He's appealing his conviction.
Right.
And this question's coming in from Joel and Steve. They're on the road. They're asking, who is the onus on for bad lawyering since filed by appellate attorney?
Well, I will say, since I'm not a lawyer in Tallahassee, and as a law professor, we've always felt more free to criticize. It's one of the reasons why we get a bad rap. That and Socratic method, both things. That the appellate lawyer, unless he had his head in the sand and wasn't paying any attention to a trial that involved relatives of his client, he had to know that this was sitting there also and didn't file until the last minute. One of the questions, Tim, that I would like asked at this hearing is when the appellate lawyer was first aware of the potential conflict here. Not simply Daniel Rashbaum, but the appellate lawyer.
Yeah, well, it would, yeah. I guess it would, the first they could argue would be, because they weren't going to call Dan, it would have been when the first witness list came out and Charlie was on it, right?
Right.
And especially, we know at least in July, he was served a subpoena for trial care of his lawyer.
So that means the appellate lawyer was sitting on this for as long as Daniel Rashbaum was.
Well, Daniel Rashbaum got the subpoena, not Mike Ufferman. So Michael Ufferman's a very good lawyer, very good appellate lawyer. And I'm sure if it came to his attention, he would have filed it much earlier. So I don't know about that. My question is, when did Dan and Alex know they had to build this Chinese wall? When did they talk to the lawyer? And did they hire this lawyer? When did they hire them? And who approved the hiring and who paid for it? Did Donna pay for it? Did Harvey pay for it? All those are information we need to know, because then that will show that this is just a game being played at the last minute.
Well, Tim, do you think that Daniel Rashbaum and Alex would say that the Chinese wall was established at the moment that co-counsel was hired?
Of course, they're going to say that. They're going to say that. They have to say that. And,
yeah.
And that's what Alex does say in his motion. And he mentions when he got hired, and he says that.
Okay.
So what was the conversation? Why that Chinese wall had to be made? Why did they build that Chinese wall? Let the judge Everett do it in camera with Alex and them, and let the judge see why.
And so now, obviously, we're all scrambling, to understand what this means. And thank goodness we have Joe and Tim here to explain it for us. But now, what do we expect overnight? I mean, are we waiting for a motion to be, or for a response from the state to be filed? Do we expect that to happen today, tomorrow? Like, how quickly could this be addressed? And with everyone on their way there for a jury selection, I mean, what can people expect?
All right. So according to the pleading, Michael Ufferman went straight to the jail to talk to Charlie on Saturday. Michael Ufferman is the appellate lawyer. He's here in Tallahassee.
Okay.
And Friday afternoon, Saturday visit, Monday motion. So Ufferman filed it as soon as after he talked to his client. Maybe he got brought the issue. He talked to his client, and he was authorized to file the motion to protect him and to assert that the privilege is not waived. So it looks like Mr. Ufferman did what he was supposed to do when he was supposed to do it.
Okay. Well, they're going to have an answer from Georgia Kaufman, whether it has to be in writing or whether they can go right to a hearing and she can present it early. I guess if I were Judge Everett, I'd rather see it first.
Right.
But I mean, trying to answer that question is difficult, Ileana, because I've never seen anything like this. So how fast it is.
So this is not common then?
No.
No, absolutely not. This is not something a lawyer in this town would ever do in front of a judge they have to appear before. Okay? You got to appear before that judge again. And if you play these shenanigans and you do this at the last minute, in the highest profile case, knowing what you know, don't bring it to his attention. Judges talk, and it's not good. Nothing here is good. The state is over here having to balance two things, right? We want to put the best case we have because jeopardy is going to attach, and that includes Charlie. On the other hand, we don't want to jeopardize a conviction if we get one by doing this. So they're weighing both of these, and really what's right. One, they want to make sure they get the conviction. So they're not going to dump Charlie just for the sake of this last minute motion.
I'm going to pull up Joel's comment, even though I didn't really want to. He's asking if jury selection is still happening.
So we should turn around.
He's like halfway.
Go home. It's not going to happen until this is resolved.
I think there's going to be some kind of resolution. And I think this is where a judge can come in here, put the pressure on these players. He's smart enough. He knows all the facts. He knows. You saw what he did about the waiver. He did it a couple times more than he really needed to about the waiver, about, the Daniel being a witness. He did that multiple times to protect the record. He's going to have this thought out, but we're not going to know until the state files their response.
Right.
And once that's filed, we'll get an idea. And you're going to probably have a lot of motions, and you're going to have a lot of hearings. And he may tell the jury, he'll pick a jury and have these hearings be held tomorrow night and keep court open. It's kind of the middle of trial, and he might have them go until 9 or 10 o'clock to get it resolved.
Wow.
And I still say the easiest is if he finds that there is an effective Chinese wall and co-counsel can do the cross-examination, because then there's no issue of being up to speed. And there's going to be no delay. And since the defense already is taking the position that there's an effective Chinese wall, presumably the only place where you would hear a disagreement, if there is going to be one, is from the appellate lawyer.
And
because
Charlie.
who else would have a claim? And Charlie, right? Well,
yeah. Donna's not going to complain. It's going to be Charlie and his lawyer. This will make an interesting hearings.
Exactly.
And they'll be public.
May I add, Tim, it is true that within the town of Tallahassee, this isn't good for a lawyer, but in my experience, as judges talk over city geographical boundaries, and this particular issue is not a little one in terms of the behavior. And so it seems, without regard to national TV and the coverage that it's getting other places, this is something that's going to go through lawyer circles. I wouldn't be surprised if a state bar meeting doesn't have an equivalent case like this in terms of the ethics and what should happen as a hypothetical that is talked at one of the training sessions. So your reputation is you're not safe because you're not practicing Tallahassee.
Right. And so, every day, not every day, but almost every day, lawyers get an ethical dilemma with a client or whatever. And we have a 1-800 number that we can call. We get ethics hotline opinion, where you can call and say, and you're anonymous, hey, this is what's happening. What do I do? Then they refer you to the rule. They give you a bar hotline number so you can go back to it. Then you get an idea what you're supposed to do. Then you have to do it. Did Daniel contact the Florida Bar Ethics and get an opinion on what the situation was? Did he get that or did he not? Right.
And when did he get it?
Right.
It isn't enough if he got it last Thursday when this was sitting there as a looming issue.
And some were asking, hello to friend of the show, KCL. Some were asking, is it strategic or is it incompetence?
This is the one the law professors feel freer to answer.
They do.
I'll give that to you, Joe.
It's hard for me to believe it's incompetence because this is not an issue where you don't have a fairly clear idea of what the parameters of the problem are. I mean, we've been talking about the questionable judgment in a lawyer trying to represent two clients seriatim in a matter that is effectively the same thing. It's just been divided up into two trials. And at that point, it seemed to me the judgment was bad. And I think I haven't heard a lawyer anywhere who said it was good judgment to do it. This seems to me, I think Tim is right that I think that sequence of whether they were texts or emails that alerted them to this issue, which meant that the state decided it needed Charlie, which I, as of yesterday, couldn't imagine why they would be calling Charlie, raised this with them. And now it's strategic in terms of trying. I think what it is, when you're thinking on the fly, I think what it is really an effort to maybe to push the state to not call Charlie.
I think that's
See if they can
exactly
manage that, right? Yeah.
They waited to the last minute so that they know the state's ready. They got their subpoenas out. They got all their witnesses. They're ready to go. And maybe the state will just not call him because it messes everything up, and that'll help us.
And I know that you guys were talking about reputation and, what you should and shouldn't do as an attorney, but is there any kind of like legal consequence for pulling a stunt like this?
Absolutely.
Yes.
The court can hold them in contempt. If the court refers it to the Florida bar, or any other attorney can file a complaint, or they have an obligation if they see something that's a violation to send a complaint to the bar, or the bar on its own can, if this goes in the newspaper and there's findings by the court or the bar itself can do their own investigation and uncover. But it won't probably be done until after this case is resolved. But it just seems like this issue should have been brought up a long time ago.
Joel, if you're listening, unless you have anything else, please put it in the chat immediately. I'm going to wrap because our kids get out of school in 20 minutes and I'm going to be late. I just texted the school right now. But Joe, Tim, is there anything else you guys want to share? Any kind of final statement?
Yeah, I would just add one thing. I cannot imagine a credible explanation for what happened here that doesn't look like what I call the shenanigan. But I want to say that perhaps somehow there is one. And if so, a lot of at least what I've been talking about, a reputation and everything else, would not still adhere. So I want to at least leave that opening because I think, I know what I've said is pretty harsh. And if there is a way that they can explain it, then I don't want to be heard to criticize something that maybe has an explanation to it. I just don't believe there's an explanation out there.
I agree. You look at things and, you drive by, you like a car crash, you're like, oh my God, that person did it. And then you realize, no, there may be an explanation, right? But the only thing I'm thinking is nothing was in the response. Nothing was in the response to say why this was delayed, why this was late, why this wasn't filed, why it didn't get brought to the court. Now, there may be a good reason. I don't know. And maybe they were told that Charlie was not going to be called, and maybe they found out that he is. If there is a good response, I agree with you. Let's hear that response, give them a benefit of the doubt, but this does not look good on any of the lawyers.
And Joel is asking, as he's driving up to Tallahassee, will motions be heard tonight? Do we know?
No, there's no response. No, there's no response. I don't think tonight. I think tomorrow. They're going to go to court early, probably about 8 o'clock before the jury. And this is going to be brought. And I'm sure the state is going to respond before then. But they have to get together and figure out what they're going to do. They got to talk to the elected state attorney, Jack Campbell. They have to talk to the victim's family, Ruth and them, and see, what do you do? Are you okay? We might have to continue this. So we don't know yet.
And I would add that very clearly, Judge Everett is going to work as quickly as humanly possible to get this resolved. How quickly that's going to be in the circumstances is a little harder to tell, but he's not going to be delaying for a moment longer than is necessary to get it decided.
And just to update all of you guys, STS Nation, first of all, thank you for being here. We appreciate all of you guys. None of us knew we were going to do this live show. And I think 3,600 of you showed up at one point. So thank you. Please remember to hit the like button, subscribe. Tomorrow, I have no idea what the plan is for STS because things have changed. So I am going to speak to Joel and to Steve Cohen and to Space Coast, and we're going to assess to see what's going on. If you guys hear of anything, a motion, anything filed overnight, please feel free to reach out. You can email us survivingthesurvivor@gmail.com. It takes a village for all of this to work. So if you guys hear of anything before we do, please let us know. I have no idea whether or not Joel is doing anything later. I know he's driving up to Tallahassee and it's a very long drive from Miami. So I'm not sure what time he gets in, but we will be following this, obviously. And if there's breaking news in this case, we will continue to bring you live updates like we did right now. So please remember to turn your notifications on. Make sure that they are set to all if you want STS notifications. And again, a huge thank you to Tim Jansen and to Professor Joe Patuto. You guys have been amazing, not just today, but for your coverage over the last couple of weeks. So we thank you both.
Ileana, I'm doing court TV at 9.
Okay.
So if I get any updates, I'm going to mention it to them tonight at 9 o'clock.
Okay, cool. And then I'm sure we'll text you. I'm sure we'll text both of you.
Okay.
Okay. All right. Thank you so much to everyone. I cannot find the show close. Give me 1 second. All right. We're ending. Thank you so much. We appreciate you guys. Bye.
Bye.